Hello, and welcome to our first and maybe only mini episode or minisode of Ctrl-Alt-Speech. I'm not the voice you normally hear. My name is Leigh Beadon, and I'm the producer of Ctrl-Alt-Speech and the Techdirt podcast. And as some of you probably know, we weren't planning on having an episode this week. Both Mike and Ben, your hosts for Ctrl-Alt-Speech, are on vacation. But after weeks of waiting, the Supreme Court chose the most inconvenient time possible to release its much-awaited NetChoice ruling, which has some major implications for speech online. As you know, we've been following that for a long time. So we dragged Mike briefly off of the streets of his vacation to come in and walk us through some of that news a little bit, just because we didn't want to leave you all waiting for a week or two before we could talk about it. So, Mike, how's vacation going?
Well, it is less fun when I suddenly have to run into a hotel room and record, but we figured it was worth it to do that. But we'll try and keep this short and sweet so I can get back to vacationing.
Yeah, absolutely. So to that end, why don't you start out? Just give us a quick explanation. What happened? What came out in this ruling? What are the immediate effects of it going to be? And, what are your immediate thoughts on it?
Yeah, sure. So it's actually two decisions in one. There was an assumption that would probably happen, though they could have decided each case separately because the Florida case and the Texas case were actually heard as separate cases on the same day, involving some of the same lawyers and everything. But they did combine it into a single ruling, and the ruling sends the case back to the lower courts is the bottom line. And on that point, it's actually a 9-0 decision. All 9 justices decided to send the case back. The reasoning why is mostly agreed upon, but that's about it. More or less, there was an issue that came up only at the oral arguments and hadn't really been discussed before that as to the sort of posture of the case and whether or not the NetChoice and CCIA, who were the two trade groups that brought both cases, were challenging this as a facial challenge, basically saying the entire law is unconstitutional, or as applied. Basically, if this law is applied in these cases, that use of the law would be unconstitutional. And throughout the cases, it was everybody, sort of pictured it as being a facial challenge to both the Texas and Florida content moderation laws. Both those laws were designed to effectively limit the ability of social media sites to moderate certain types of political content. And the challenge was, is the entire law unconstitutional? And so during the oral arguments, a bunch of the justices started asking these questions about whether or not it makes sense to be a facial challenge. And there are elements of when you challenge a law on its face and say the entire law is unconstitutional, you sort of have to look at everything that the law applies to. Whereas almost all of the discussion in the lower courts and all of the briefing was very specific to how the law applied to social media feeds, Facebook feed, YouTube feed, Instagram feed, those kinds of things. And it was a little weird during the oral arguments, like you heard justices talking about things like Etsy and Uber and whether or not the law applied to them in any way, and what did all of that mean. And so that's kind of where they came down, where they said, this case is being positioned as a facial challenge, but it wasn't litigated as if it was a facial challenge. There wasn't an attempt to go through the law and to say, here is, all the ways in which the law can apply, and none of them are constitutional under the First Amendment, which would be the way that you would normally challenge the law if you're doing a facial challenge. And so
Right.
The general decision was that because it wasn't litigated that way, and it should have been, we have to send this all the way back down and go through this process all over again as a facial challenge, and going through all the steps that make sense there. But from that, there was a lot more in the decision, which is that the majority decision, which was written by Elena Kagan and was signed on to by effectively 6 of the justices, though Justice Jackson did not sign on to a few parts of it, then went on much further and said, now that this case is going back to the lower courts, we have some notes. And
Right, right.
we have some notes about how the First Amendment works and about how the First Amendment applies to social media and internet websites. And let's just be clear that the First Amendment absolutely does apply, and websites have a First Amendment right to editorial discretion in terms of how they display feeds and what content is shown. And the other cases that people have relied on in other cases, or in these two cases, the states relied on these other laws, these other cases like Pruneyard and Rumsfeld v. Fair. Those cases don't really apply here. And Kagan is pretty direct that the Fifth Circuit ruling, which upheld the Texas law,
Right.
was crazy and made no sense. And she's pretty explicit. And again, five, possibly six. I mean, really, six of the justices signed on to most of that. Five of the justices signed on to much of it, and sort of said, okay, if we're going to go through this again, let's get a few things straight about how the First Amendment works and the fact that it does, in fact, apply to internet companies. And so it's a weird ruling. It could have been clearer. I mean, if we had gotten all of that as not as a side issue, but as the main ruling, the applicable part of it, that would have been even stronger. But this is giving pretty clear instruction to the lower courts not to go off into crazy land like the Fifth Circuit did.
Right, because I know that Kathy Gellis on Techdirt. I've read your piece on Techdirt that you also stepped away from your vacation to write,
Yes.
and hers today as well. She argues that it's sort of strange framing, and that arguably that dicta in the ruling, all of that additional stuff, is really the stuff that answers the question the court said they were taking on when they took on the case. And so it has created a sort of strange situation where you were also saying to me earlier that, everyone's trying to claim victory over this. Like, it's
Yeah.
allowing the people who have been smacked down to maybe pretend they weren't. Is that kind of what's happening? Or
Yeah. I mean, the most obvious of that is Florida's Attorney General came out and declared victory because technically the Supreme Court rejected the 11th Circuit's ruling and sent it back to start over again. But the instructions were pretty clear, and in fact, in the part that was chastising the Fifth Circuit, they make clear, like, the 11th Circuit, the only problem with the 11th Circuit ruling effectively was that it didn't focus on the fact that this was a facial challenge and making sure that all the elements necessary for a facial challenge were there. There are some other things too, but because it was a 9-0 ruling on that main point, all of the other opinions, and there are four other opinions, are sort of addressing different elements. Even if they sort of appear as dissents, they're not. They're technically concurrences.
right.
There's two. There's one from Justice Thomas alone, which I would classify as just kind of whining.
Okay.
Whining that the court is even, doing this, like, it should never have said anything more than just the basic part, and then going through like what Justice Thomas believes is a history lesson of all the times the court has gone too far and has been overbroad in its reading of things.
Right.
And then there's the Justice Alito one, which was signed onto by both Thomas and Gorsuch, that just emphasizes, like, we agree on the point that this should be sent back because there's a facial challenge and should be heard in a different way, but everything else is dicta and should be ignored. And it basically says that pretty explicitly. And then Alito goes off on a whole bunch of other nonsense and tangents, which more or less suggest that, he would probably side with the Fifth Circuit, and is almost saying, like, the Fifth Circuit could just reissue their, nutty decision, and just say, make sure the elements regarding a facial challenge is included, and it would be fine. But, now we know that beyond those three, it doesn't look like that Fifth Circuit type of ruling has the votes to actually, have the Supreme Court rule that way.
Right. But does this still sort of potentially give those courts ammunition if they still want to be difficult about this, to like say they don't have to follow that? I mean, what happens now? I think everyone's saying
Yes.
this is going to make its way back before the court eventually, whether through these cases or through others. So like what happens now in the wake of this ruling?
Yeah, partially that's unknown.
Right.
So, because they threw out the lower court rulings, and the lower court rulings were all preliminary injunctions blocking those laws from going into effect, technically those injunctions have just gone away, which probably means that NetChoice and CCIA have to immediately run back to the lower courts and file for another preliminary injunction, and then we go through this whole process all over again. And we'll see. In both Texas and Florida, the district courts did side against the states and with NetChoice and CCIA. I think, assuming that they can write up a version of the case that makes shows the elements for a facial challenge, it's hopefully likely that the lower courts will do that again. Then it bounces up to the appeals courts, and we go through this whole same process again. And, there's a decent likelihood that even though there is all this technically dicta in the case, that the Fifth Circuit will still try to make their case and basically do the culture war thing and take notes from Alito and Thomas and make this argument. But it doesn't look like they would then have the support of of a majority on the court when the case actually made it back. But, we'll see. So it's, I don't know if it's next year or perhaps more likely 2 years from now that the Supreme Court is basically going to be hearing NetChoice 2, I think is
Hmm.
the way they would probably call
Yeah.
it. And we'll kind of have to go through this whole dance again and see what happens at that point.
Yeah. But certainly there's reason to have, I guess, more confidence than before that the Supreme Court will see the
Yes.
issues actually at play here.
Yes. So
Yeah.
the good parts of this are that, 6 out of the 9 justices really did understand appear to understand the basics of the First Amendment and how it applies to the internet, and the limits on what states can do to block uh you know block sites from moderating content in the way that they see fit. They did seem to recognize that websites as private entities have First Amendment rights for editorial discretion. They did appear to understand all those things. The fact that the First Amendment applies to the internet, this is important.
Right.
The fact
And
that
they
these
drew distinctions from like Pruneyard and those other cases that were invoked and sort of highlighted why that didn't apply here too, right?
exactly,
Yeah.
and Pruneyard is this sort of nutty case that a lot of people have relied on in a faulty way, just because they're desperately looking for a case that effectively says that states can compel entities to host speech that they don't want. In Pruneyard, that was about a shopping mall, and it was a question about people handing out pamphlets and things like that. And that ruling was always kind of a weird one, where basically they said the mall can't restrict people based on viewpoint and prevent them from handing out pamphlets. But it was a very, very narrow ruling when it came out, and it was very specific to the situation in Pruneyard. And there were follow-up cases that sort of tried to expand Pruneyard, and in fact really ended up doing the opposite of that and limiting the facts specifically to like Pruneyard shopping mall. Like
Right.
I don't think I think even other shopping malls might not even have the same result as Pruneyard had. There were some very, very specific parts to it. And here, in the majority opinion, they made clear like Pruneyard is distinguished because Pruneyard's business was a shopping mall. The business of Pruneyard, the shopping mall, was not speech or expression in any way, whereas social media is about speech and expression, and that's what makes the big difference here. And so, it really makes it clear and has really good, clear language that people will cite that says that Pruneyard doesn't apply to social media. And I think that's actually really important, because so many of the people who are really looking at trying to pass these kinds of laws kept pointing to Pruneyard as their main, the main proof that you could force social media companies not to moderate certain content.
Yeah, I mean, I follow these things less closely than you do, but I've seen it invoked countless times by
Yes.
people, just as an example that in theory, this can be done, sort of,
Right.
yeah. Speaking of that, like powerful language in the ruling and impact on other cases and laws, like, do you see that having an immediate impact? Are we going to start seeing the language from the dicta in this ruling like turn up in other cases and things soon,
Yeah, probably. I mean, the annoying part is, right now, like every state is trying to pass various kinds of laws, not as direct as the Florida and Texas laws, but we're seeing it in all the age verification laws, in the age appropriate design codes, some of the privacy laws. There's some, a few other laws as well that sort of all touch on this in terms of like, how algorithmic feeds can present content.
right?
So all of that stuff is coming up. And, if this ruling had been much clearer, it might have made clear that most or all of those laws are probably unconstitutional. Whereas here, there is language that is now going to appear in those cases, and as they're being heard, and I'm sure we'll see filings in some of the cases that are challenging these laws, pointing to language in those laws as sort of an emphasis and an exclamation point. The legislatures and the lawyers representing the states who are pushing for those laws are going to point to the fact that it's dicta, and they're going to say, that none of that applies, none of that matters. This is different. The thing that will most often come up is that only applies to, moderated feeds, and we're not doing that. We're talking about something else entirely. I don't think that's true. I think they're sort of misrepresenting it, but it doesn't give a clear thing that will knock out these laws. But the language from this is certainly going to show up in a lot of the court hearings, and the filings in all those other cases, I'm sure.
Yeah. And then what about the other aspect of this, sending it back to the courts to make sure it got a ruling on the whole law on its face? Is that going to impact the path of some of these other laws? Or like other circuits and other courts going to try to
Yeah.
avoid making that same mistake and make sure that they start evaluating these laws as a whole and their constitutionality from
Yeah.
the get-go?
Yeah, I'm sure. I do wonder. I don't know what that will mean for some of the other challenges. If, because it's NetChoice itself, that the trade group is the one challenging a lot of these laws, not all of them, but a lot of them. And I do wonder if that will make NetChoice rethink and see if they can, I don't know where, I mean, there's so many different states and cases and so many different things. So I don't know procedurally where they are in terms of what they can do to sort of, amend the original complaint or what. Some of them that might be possible. Some of them I'm guessing it's not. But, I do think, yeah, just the fact that they're going to have to be explicit that they're doing a facial challenge, and then make sure that all the elements that are necessary to do a facial challenge are going to have to be shown, will make it interesting. And I imagine some of the cases are going to shift in terms of what their focus is right now based on this. But none of what came out in that ruling, I think, really changes the underlying factors. It might just change the sort of litigation posture of how these
Yeah,
cases go.
makes sense. Okay, well, I think we've kept you away from your vacation long enough. I'm glad we had time to give our listeners this little update. For everyone listening, as I said, we will not be back this Friday with a full episode, but we will be back next week. Ben is going to be on with a guest host that week. And for those of you listening on the Techdirt podcast feed, where we are cross-posting this little episode because we know it's of interest to our Techdirt listeners as well, come join us over on the Ctrl-Alt-Speech podcast as well. Subscribe wherever you listen to your podcast. Same goes for Ctrl-Alt-Speech listeners who aren't yet Techdirt listeners. And yeah, we'll be back with a full episode as soon as we can. Thanks, everyone, for listening.
Yep. Thanks.
Thanks for listening to Ctrl-Alt-Speech. Subscribe now to get our weekly episodes as soon as they're released. If your company or organization is interested in sponsoring the podcast, contact us by visiting Ctrl-Alt-Speech.com. That's CTRL-Alt-Speech.com. This podcast is produced with financial support from the Future of Online Trust and Safety Fund, a fiscally sponsored multi-donor fund at global impact that supports charitable activities to build a more robust, capable, and inclusive trust and safety ecosystem.